Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss the all-important issue of opening up of Indian market for the foreign law firms, the impact of such a decision, and also link it to the growth of the Indian economy, the opening of the Indian economy, the free trade agreements that India is now signing, the most latest being with the United Kingdom, which is being planned. All of this and the opening of the Indian market is also a part of this great opening up that the Indian economy is doing. How will it benefit us? What are the other implications? What are the learnings? All of this. And I have somebody who runs one of India's largest law firms with me today. He is Mr. Mohit Saraf, a managing partner of Saraf and Partners. Good to see you, Mr. Saraf, and looking forward to some interesting comments from you today. Without wasting much time, let me get straight to the point with you today. First few words on this decision of opening up of the Indian market for foreign law firms.
I would say the Indian market has been waiting and global players have been waiting for this decision for almost 10 years. I remember 2-3 days back, I was actually having lunch before the notification came in. I was having lunch at the Oberoi's with the chairman and a managing partner of one of the top world firms, a global international firm with large office in London and New York. And I said, any day the notification can come, but the person of Indian origin, who's an advocate and who's actually passed out from India, who runs the Singapore desk, he says, Mohit, I've been hearing this for the last 5-7 years. So this is actually a long-awaited discussion and long-awaited move. And it's a positive move, good move. And if you look at global players, global economies, similar economies, we are way behind the curve. Most countries have opened up significantly. So I would say it's a positive step. It's not that everything will get done overnight, but it's a positive first step. And we should full support this move. And this will go a long way to improve our legal system in this country.
So happy to see you endorsing this great move by the government also. And ahead of the India-United Kingdom FTA. But I want to understand specifics from you. So I also want to understand from you, to what extent is the legal market for foreign law firms that has been opened? Could you share with the viewers?
So basically, if you look at the notification and then you look at the BCI clarification, right now what it is coming out is that they are allowing foreign law firms to set up offices in India, number one, practice foreign law in India and or international law, and actively advise foreign clients. Now there is a confusion whether if an Indian company is acquiring a target in the US, can a foreign firm advise or not? Because the main rules do talk about that a foreign law firm can advise Indian clients on foreign law, but the clarification issue actually somehow does not allow that. But again, I would believe that the main rule is actually the law, and clarification is just a clarification. So I would say that the general belief is that foreign law firm, once they set up an office, they'll be able to advise Indian clients with respect to their foreign law requirement. What they are not permitted is to appear in courts or to tribunals, but they are permitted to appear in international arbitration. International arbitration is defined as any arbitration where there is one party is a foreign party. And even if it is when the venue is in India, that means the entire proceeding is happening in India. In that situation also, a foreign lawyer who may not be qualified to practice Indian law can appear before the tribunal. So this is a very, very positive step. I would say it's required to make arbitration in India more efficient.
Now, the reaction that I see these days to this opening up, remember what happened when the economic liberalization happened in India in 1991. I remember it was a Narasimha Rao government, and a Bombay club was formed. That time, eminent industrialists like Rahul Bajaj were part of it. And very interestingly, this was a club of industrialists who had operated very well in the license Raj era economy, where you used to get a quota of who could produce what kind of material and in what quantity. So everything was a controlled economy. In 91, when it was thrown open, industrialists were very scared what will happen, and rightfully so. I mean, you cannot rubbish away their concerns in a way. But now with law firms also, this seems to be happening, where the local practitioners, many of whom have earned money and flourished in the past 30 years, they are some of India's biggest law firms. They are some of India's most successful lawyers. They are skeptical. What do you think? Is this a similar reaction? Because in my view, we all benefited after the liberalization of India. What is your view on this?
Absolutely. I would say, Tarun, anytime if any regulation introduces more players, people getting nervous is natural. I would say today, when you believe that every firm in the world will have a right to open an office, a lot of firms will get nervous. But I remember a joke that in a small village, there was one lawyer and he had zero practice. Suddenly after that, one more lawyer came and then the practice grew. Then 5 lawyers came, the practice started flourishing. So it is all about, because really at the end of the day, you can't fight among yourself. You need 4 or 5 parties. So whatever said and done, this is the same thing. What happened in Bombay Club, people were very concerned. They thought that they will not be able to compete. They will perish. But I would say, if you look at Indian market, Indian law firms, Indian professionals, Indian markets have really matured in last 10 years. I would say from 2010-11 to 2023, the industry is at a different level. Sophistication is a different level. Technology, they're very technology savvy. They are talking about artificial intelligence. What nervousness they are talking about is, I would say, just a nervousness. Eventually, I would say, if the market opens up, 5 years from now, when we look back, we will say, thank God it opened up. It'll be because I would say the market is going to grow to a tremendous level. You remember, in India, we are a very subsistence economy, $3.4 trillion, very basic economy. Our per capita is $2,500. And the journey from $2,500 to $5,000 is what will take Indian economy from $3.4 trillion to $10 trillion, which will require an investment of $3.5 trillion. Can you imagine the level of investment, which we have not done in last 75 years? Can we do it in next 12 years? Answer is no. Therefore, we require a lot of law firms, sophisticated law firms, where we will learn from them and they will learn from us. And that is an important thing. And this is how they will improve and we will improve. And just imagine, Tarun, just look at it today. Look at the charge out rates for Indian market. But when you're talking about Indian market, you see the charge out rate. Leave the senior counsels because they are a different creamy layer in India. So that is what the Mandal Commission talked about. So they are a creamy layer, we remove them. And if you look at anything else, if you see today, if an international law firm will put a 40-year-old partner and charge out, and because their normal charge out rate in the US and in Europe is upward of $1,000 or $1,200-1,500. And now imagine if somebody's like that is sitting in India and his charge out rate is $1,200-1,500, then obviously I'll charge $2,000. Today, I can't even think about $2,000. And that is what it will change. I would say, what we will move is a quality law firm, quality product, where people will spend time and do justice to work. And I would say today what has happened is everybody's taking way too much work than they can handle. The fees are low, they're taking too much of work, and they're not doing justice. And that is an important thing. And I would say this is an important journey. I wish that we had started this journey 10 years back, but doesn't matter. Even in 23, and it's a very restrictive opening up. But I would say this is just a start. And I would say this will impact the entire judicial delivery system, arbitration, the criminal justice system. Eventually, you'll see a major impact. And eventually, I would say right to justice, which is a fundamental right, will come to reality. So this is a very, very good first step.
See, Mr. Saraf, you are known to do global mergers and acquisitions. You have exposure to many markets, I know. Could you share with us how markets the world over were opened for foreign law firms, which all countries opened it, which all countries are actually ahead of us in this issue, and what has been their experience, your view on that?
I would say today, if you look at Dubai, you look at China, you look at Japan, you look at Brazil, you look at Germany, all the Argentina, most areas, foreign law firms are allowed to set up an office there and practice foreign law. It is everywhere allowed. And if you, I'll give you an example, and this is something which has happened with me. I must tell you that 10 years back, I was visiting Dubai with a very important client, a chairman of a company. So we went to meet a Middle East law firm, and we had a joint venture to negotiate. And the chairman asked him, I said, what's the rate you'll charge us? He gave us his rate. The guy looks at it. I say, hey, you are a Middle East law firm. Your rate is double the English law firm's rate, which I got it. He said that. He said, yes, we are a different league. We are the top tier. A lot of English firms in this jurisdiction are tier 3 and tier 4. This is exactly what will happen in India once the market comes up. Because in India, you understand, Tarun, there are more shades of gray than black and white in India. Now, these levels of shades of gray does not happen in any other part of the world. Laws are codified, they are interpreted uniformly. That does not happen in India. So today, what is happening in Dubai, and what I'm talking about Dubai 10 years back, will happen to India. Because people who have been flown in from New York and London will have a very limited experience to guide people to make investment. And that is where the premium will come. So this is an exciting journey. Yes, I can understand people being nervous, like Bombay Club, but eventually, over next few years, we will look back and say, good, it happened.
I want to know from you, if you give me a dispassionate, I know you're gung-ho about this idea, you support the entry of foreign law firms, you're saying it's good for India, but still, could you give me a dispassionate assessment of the impact that it will have on Indian players? Will it make them more efficient? Will many be wiped out? Will they would rather improve themselves? What will happen? I mean, what will happen to the tier 3 firms, to the tier 2, to the tier 1? What will happen?
I would say, let me explain to you, Tarun. Maybe we should not look this issue from only law firm perspective. I think, in my view, that is an error. We should look at it as an entire legal perspective and understand who are the stakeholders. Lawyers clearly are one. Law firms clearly are. Judges are. Arbitrators are. Policy makers are. And legislatures. So I would say executive. So I would say, and then after all, the common man who has a fundamental right to justice. In my view, this entire thing will improve things dramatically going forward. I would say today, if you look at, I was at the India Today enclave, and where somebody was asking the Chief Justice about delay and about a long list of delays and things like that, and how there have been so many lakh crores of cases pending. And it was in a way to embarrass the Chief Justice. But really, if I look at today, is it the Chief Justice alone or judiciary alone need to be embarrassed? No. I would say arbitration was set up as an alternative to litigation. Arbitration have failed in India to deliver quick, speedier justice. If you look at the government of India, they are the largest litigator. They have failed. They have clogged the system. If you look at the legislature, the Section 73 of Indian Contract Act, which describes damages, it actually is so outdated. Today in India, you make more money by breaching contract than by following contract, which is not the case. So I would say today, if you have these problems of backlogs and delays, it is not only the Chief Justice or the judges to be blamed. The lawyers have taken dates after dates. So everybody has to be blamed. And today, when you ask the impact, in my view, this will have a significant impact. When these people will show up in India, they will get into policy discussion with the government, and we will start making legislative changes. Right now, most players, it is not in their interest that there should be quick disposal of case. And therefore, we are just going in circle. So I would say in next few years, we will find gradually things improving, enforcement of contract improving, enforcement of foreign awards improving, and all the substantive law will change. A lot of these things will happen. And again, I would say from the law firm perspective, I would believe that the markets are, remember, the foreign law firms, wherever they compete, they will only compete with the top tier law firms. They are not going to compete with the bottom firms who are doing regular work, day-to-day work. So in those firms will only benefit one way, the prices will go up. And if their prices go up, they will have a more ability to pay their associates and retain them. So I do not see, now I cannot talk about next 6 months and 12 months. But if I look at trajectory, it will be like a Bombay club. Just look at what was the total output number in 1990 and what are we today. We have dramatically changed. And I would expect in next 10 years, the legal bill of corporates will go 4-5 times. Therefore, we are staring at a very big upside. These disruptions should come when economy is moving up. And we clearly are moving up. So this can be absorbed very easily by current players and very effectively.
Now, Mr. Saraf, Prime Minister of India, Narendra Modi, wants to make India a hub of arbitration. Law Minister Kiran Rijiju also said the same recently at the Delhi Arbitration Week. Very recently, it was concluded. Now, this opening up has happened. Very interestingly also, foreign lawyers have been permitted to appear in international arbitration in India. What do you think is happening here and its impact according to you? And will India change and Indian arbitrators change for the better? And will it bolster India's chances to become a hub for arbitration? And will also encourage more Indians to arbitrate in India? Your holistic view on this?
Clearly, I would say today we have lost out the plot of arbitration in India. I think the process is delayed way beyond, because really at the end of the day, the process was that every arbitration should conclude in 12 months. Right now, it is getting extended way beyond. It's an inefficient process. People, arbitrators and lawyers, they have not changed themselves, that they come to an arbitration fully briefed, fully prepared and resolve the issue. They come and they have, I think they believe it's the same way like the litigation. Now, in a litigation, when you have a chief justice, I've got 80 cases every day. I can understand that. That's not the case with arbitration. And arbitration, you have only few matters, and therefore you have to come prepared. Same thing. I think that the change has not happened. So I would expect today arbitration is losing. Today, most clients want arbitration venue to be in the US or in UK or in Singapore. They want outside India so they can get foreign experts, foreign arbitrators, and things get decided quickly and people get into detail. Now, the minute it is India, it doesn't get. So today, what this proposed law is saying, that if there is one party which is a foreign to the dispute, then it's an international arbitration. If it is an international arbitration, you have been doing all this international arbitration outside India. Now do it in India. So anything which was not there, what they're saying is, please bring it to India. Even if the governing law of the document is English law or Indian law, we don't care. We will allow foreign lawyers to argue this matter. In my view, this will only improve. Let's assume there are 5 parties to a dispute and there are 1 party is a foreign. Now it will be done in India. Then 4 other parties will have lawyers in India, right? So it will only lead to a better thing, because something which was not there is moving to India. So in my view, it is a first step. This should, in a way, should be a wake-up call for players like arbitrators and wake-up call for players like arbitration lawyers, that this is an alternative to litigation. Everybody needs to come fully prepared, need to resolve the issue. And because the entire proceeding of arbitration is confidential, it should not mean that everybody's relaxed. The purpose of confidentiality today, a lot of my clients say that it is better that it is in public view. If it is in courts, then people are more proactive. Judges are more proactive. Arbitration, because it's confidential, judges are not proactive. And I would say this is not going well. It is actually making us a very sorry figure globally. And I would say that this is one step. Because remember, when you create some sort of a shift in your backyard, that will change dramatically. So now people will say, we will do an Indian arbitration. We'll do an international arbitration seated in India. And that will start moving things faster. And therefore, in my view, that is a very nice way to bring change. And
I want to ask you a question because you interact with corporate India a lot. What does corporate India think about Indian arbitration? Because generally there is a saying, people vote with their feet. Voting with the feet means you can praise Indian arbitration, but the moment you want to arbitrate, you go to Singapore, you go to London, you go to New York, which means that the industrialists are not walking the talk. They are saying that they want to arbitrate here, but they don't arbitrate, which means that it conveys something, doesn't it?
I tell you one thing, Tarun, you have to understand who wants to go where. Generally, if you are a breaching party, and whether you are a foreigner or an Indian, you would prefer to work in India. Because arbitration also is like a litigation process. It's not time bound. It's only time bound in statute books, and everything is done at ease. But if you are a claimant, you definitely want, because really at the end of the day, you're losing money. You need to recover. You want to be outside so that you can your claim can be quickly settled. And therefore, India is really, and I remember speaking at National Judicial Academy where I was taking one of the course, and I said that in India, because of the system, it makes more sense to breach law, because you make more money by breaching law, breaching contract, than by following contract. And that is the reason why today, wherever Indian houses are doing large contract, stakes are high. They insist that it should be outside India, because then they are sure that this matter will get done in 12 to 18 months.
You mean it's certainty of arbitral award, certainty in terms of the time frame. That is what corporate India is looking about.
Two things: certainty of a time frame and commitment of tribunal to get into detail. Both are equally important. Time period, but an award which has lack of application of mind also doesn't work. So there has to be both the things. One is certainty of award. The second is sophistication of arbitration tribunal to understand issues and to spend that time. They are very, very senior people. Indian arbitrators are very good, very senior, but everybody has to make their hands dirty. They have to spend lakhs of pages to give an award. Now that is an important thing. If you are taking way too much arbitration, then you will not do that work which is supposed to be done. Arbitration globally is done by arbitrators and lawyers. They take 2, 3, 4 matters and they spend days and days. It is an expensive process, but it's a proper process. Right now, what we are doing is we are making it somewhere in between. So we are not getting into detail because we don't have a bandwidth. We are taking too many matters and we are not doing justice. So it's neither here nor there.
I want to ask you something, because international arbitrators are now allowed to practice and appear here also. One arbitrator who does a lot of international arbitrator told me, Tarun, basic things like numbering of pages, how the documents are assembled, even that is much, much better abroad in Australia and America and USA. There is a format in which documents are assembled. When you look at it, the numbering is so much better. The color coding is there. These all things are very important when you have to go through volumes and volumes of data. Do you think these international standards will come to India with this opening up of foreign law firms for the Indian market?
Absolutely. I would say, Tarun, absolutely. I would say just by this Indian arbitration, international arbitration, where they have allowed foreign lawyers to come, I'm telling you, dramatic changes will happen, because then people will start comparing and say, if you have an Indian seated arbitration, which is an international arbitration in India, you're getting things done much quicker, and you're getting much higher quality award compared to the others. And people will gradually start moving. And that's what it is important, is that today we are not able to compare. Because remember one thing, that also is, if you look at the Indian court litigation strategy, when your case is weak, your pleadings are so poor, you write same thing 500 times, and you confuse the shit out of the judge. Now that is what the problem is, that in India you should be punished for doing wrong pleadings and wasting time. And that is the issue which will change. Because remember one thing, right now, there's no competition. Everybody is doing the same thing. Now, if you inject a competition, you get somebody who's doing things differently, and people start see differently, then things will start changing. And that is what it is. That it's a slow process, but it's a very good process. Because at the end of the day, we need to make sure that general corporates are worried about breaching a contract, because it should be very effective. Remember one thing, if you look at it, like a cost of capital, you understand, most of the corporates in India, the cost of capital is 12-13%. If you add the foreign exchange hedging. Now, if I'm delayed in payment, the courts are awarding 3%, 2% penalty. If that is what you're doing, is why will you pay? If your cost is 13-14% and the courts are not awarding the damage, you should award damages based on cost of capital. That if you did not pay in time, then you should pay what is your cost of capital. You just do that. And that is a legislative change. 50% of our backlog at fresh cases will disappear. Because that's an important thing. This has to be done together. Right now, what is happening is there are few people like me who are talking about it, that this is not going anywhere. But most people feel that they're benefiting out of delayed system, and therefore nothing is happening. So this is one way of improving the system, and this is going to go a long way. In my view, it's a small process. Don't think that this will change and create miracles for the country. No, but this is a one step at a time. And I'm happy that at least we're taking the first step, and then the second step, and the third step. Because after the first step, you'll see how you benefit, and then the things will change. It will be like a Bombay club, that the law firms in India will get confidence in next 1 year.
Thank you so much for sharing your perspective today. You give a big thumbs up, as I can say, to the opening up of foreign law firms for the Indian market. You also said that it will improve the Indian ecosystem. You also said, shared with the audience your experience of other countries opening up. You also made a very frank assessment of enforcement of contracts in India and why it will impact the decision of the foreign investor to invest in India, because he looks at certainty in enforcement of contracts. And you also spoke of the arbitration system and why it needs to be improved if India wants to become a hub of arbitrations. Thank you for sharing all your views in a free and a frank manner. Look forward to your participation on our show on the enforcement of arbitral awards, which is again very important issue. But appreciate you joining us on this very, very important issue. Thank you so very much.
Thank you, Tom. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.